Hi, good afternoon, everybody. Welcome. Welcome to Volpe Koenig CLE webinar, Artificial Intelligence, Patents and ABA Ethical Considerations. My name is Anna Melandra. I am the Director of Marketing for Volpe Koenig. We're a full-service intellectual property firm based in Philadelphia. And welcome to our April webinar. This course has been approved for 0.5 substantive and 0.5 ethics CLE credits by the Pennsylvania CLE Board. Volpe Koenig will report your attendance to the Pennsylvania CLE Board's portal, but please stay on the webinar until the end so your attendance can be verified. You'll be issued your certificates by email. Now, if you haven't already downloaded the course materials, you can find them in the handout section. You'll find our PDF of our presentation today and also an evaluation form. We'd really appreciate it if you could return that evaluation form to us after the presentation is done. Now, all attendees have joined the webinar in listen-only mode, which means you are muted, but we are taking questions throughout the webinar, so feel free to go ahead and enter your question in either the chat or the questions section, and the presenters will be answering those throughout. And now I will turn over this presentation to shareholder Jay Halt. Jay.
Hello, good afternoon. Thank you for joining us this afternoon. So we will jump right in it. My name is Gerald Halt, and I'm a shareholder at Volpe and Koenig. I'm going to be presenting along with Jeff Klobicki, also a shareholder. Next slide, please. So I'm just going to provide a brief overview of the presentation. First, we're going to get into the terminology that's used in AI and some of the related technology. The terminology can be confusing and is certainly not used consistently. And the terminology also changes as the technology changes. We'll also go over the technology basics. We'll try to keep it pretty high level, but it's important to understanding the underlying issues in order for us to provide, it's important for you to understand the underlying technology in order for us to explain the ethical considerations that are being raised. And we will go into the ethical considerations. They are varied and they are really popping up in ways that you would not expect. We'll briefly go over considerations for authorship and copyright and inventorship for patenting, and we will discuss the patenting of AI inventions. And throughout the presentation, we'll sprinkle some AI folklore. So if you're a fan of science fiction from 2001, A Space Odyssey, to the recent Marvel movies and Jarvis, there's enough folklore, myth, and movie magic to confuse even the most ardent AI enthusiasts. So we'll present some slides throughout. Next slide, please. Okay, what is artificial intelligence? So this coin was coined by John McCarthy, and he's an AI research pioneer. He said AI is science and engineering of making intelligent machines, especially intelligent computer programs. More commonly, artificial intelligence is generally thought of as a type of computer programming along with a computer that mimics or tries to mimic human intelligence. As we'll state many times, AI is a really vague term, and it changes over the years as technology changes and improves. Next slide, please. So machine learning. Machine learning is a branch of AI that uses specific algorithms and selective data to what we'll call train the algorithms to imitate the way humans think. And really, artificial intelligence today is really more machine learning. So because we haven't really achieved anywhere near the intelligence of humans. Although the programs are getting better, they're getting faster, and they're achieving greater insight, but we're really not there yet. Next slide, please. So there are several other terms that are often used in conjunction with artificial intelligence. Big data. As its name suggests, big data is the collection and crunching of large amounts of data. And the larger and larger samples you get, you can start to see patterns emerging throughout the data, or it's hoped that you can see patterns throughout the data. So this is used in all sorts of organizations today, across Wall Street, drug analytics. There's all different types of data analytics, even for security and anti-terrorism. Cloud. So a cloud is a large number of linked data servers that are used to crunch big data and provide the processing power and storage needed for AI. So these are huge, like thousands, tens and thousands, and even millions of servers that are used to leverage that computing power for these artificial intelligence programs. And blockchain. A blockchain is a system, it's typically a distributed system in which a transaction, for example, currency or another type of like legal or non-legal transaction, can be recorded in multiple computers that are linked together in a peer network. So although blockchain is typically thought of as related to cryptocurrency, it can be used in any transaction that needs to be tracked. So in years to come, you'll likely see it used in place of a lot of legal documentation. So for example, it'll be used to streamline processes that are very cumbersome. If anybody has recently applied for a mortgage or gone through the closing process for a home, you can appreciate how cumbersome those processes are. And blockchain will likely be used to address those inefficiencies. Next slide, please. So this is our first AI folklore slide. In 2011, Watson participated in a Jeopardy challenge. So how did it go? Well, you can Google Watson destroys humans in Jeopardy challenge. So if you have a couple minutes to look at it, Google that. It's really an interesting video. Next slide, please.
Okay, thanks, Jay. Yeah, we wanted to go over some of the basics for artificial intelligence here, and it'll kind of lead into give you some foreshadowing, or it's useful when discussing the ethical issues. And here we're just showing a supervised training model here, and something like this could be used for like medical diagnostics, autonomous driving, predicting housing prices. All sorts of different things can be done with this. And it's just like a sample scenario where essentially we have a data lake, and this would be like dirty data. It's just data with different formats, could be missing fields and all of that. And then a step will be taken to harmonize the data so that essentially there's something will be dealt with the empty fields. There could be different formats of the data, so they'll be kind of put into one format. And then from that harmonized data, then we'll pull features from that, and those features will go into some AI model. And there's obviously a lot of different models out there. There's some very simplistic models, such as linear regression or logistic regression, or more like what's kind of like the flagship nowadays is the deep learning neural nets. And it'll go into that model, and then an output will come out of there. It'll predict an output of that. Like if we're looking for a medical diagnosis of cancer, it'll predict it, and then it'll be told what the actual outcome was. That'll be fed back into the AI, and that's called back propagation. And that'll adjust kind of the way the AI is processing it. It essentially adjusts weights within the AI, and so that the prediction becomes more and more accurate over time. And then in practice with the supervised model, that essentially you'll get the inputs in and then it'll make the prediction. For example, if it was like for a cancer diagnosis, you would get in kind of the parameters into it, whether it was an image or if it's certain variables that go in it, and then it'll give you whether it believes that the image shows cancer or not here. Now, one problem with the training of these models is what's biased, and this will come into a lot of the ethical issues, where essentially this is like the classic case of bias in AI that's kind of used a lot, where essentially in this case the AI was trying to predict whether there was a wolf or a husky in the picture, and in the end results, they train it on these images, and it ended up the images were all biased that because wolves are in northern climates, they tended to have snow. So the AI made this correlation that essentially if there's snow in the picture, it's most likely it's going to be a wolf and not a husky, which was not the result that was intended. And the bias that these AIs can have from the training creates two problems. Like first, obviously, the one flagged here is that if you have biased data, you're going to get biased results. So bias that goes in is going to come out, which may not be good for the problem you're trying to solve. So in this case of the wolf and the husky, the snow is something that really doesn't indicate whether it's a husky or a wolf. So it's really irrelevant. It's just like a causation is not correlation. So they're highly, correlation is not causation. They're highly correlated, but the snow being there doesn't cause it to be a wolf. And then the other issue that this kind of raises that sometimes you don't really know what's going on with the AI. In this case, the people obviously training it, the images thought it was doing some sort of facial recognition and recognizing maybe the distance between the ears and the nose shape and various features like that, but it actually really wasn't. It was reading the snow, so you're not exactly sure what the AI is learning about. And then kind of the other scenario for training is it's kind of similar. It's unsupervised training, and in this case, we don't have that feedback loop there. Essentially, the AI is just processing data, and a typical use for this is something called clustering, where we have this data, we don't really know what to do with it. So you want the AI to kind of figure out how to group the data together. This would be something that would be used in big data. We put in a lot of data in here, and then the AI will kind of derive categories for this. So it is essentially taking data that may to a human look random and then essentially grouping it together. Some type of applications for this would be like directed advertising, where you have all these users and then the AI can kind of cluster them together to better come up with ways of directing advertising. And we just put this here because I think this gets into some of the ethical issues, is whether the AI is more like software, conventional software, which just code written down in sequence, or is it more like human knowledge, because the AIs, like the deep learning neural nets, are essentially trying to model human intelligence, and they kind of replicate like a neuron here and the synapses connections. So essentially, instead of having a neuron and synapses, they essentially use weights and different functions to represent these. And so it's kind of modeling this. So it has some of the properties of software, but it also has some of the properties of human intelligence, and it's Jay mentioned before, it's like we're pretty far from there because we're using these models with the neural nets, but a typical human brain has 86 billion neurons and over 1,000 trillion synapses. So there's just a human brain is extremely complex. And it's back to the folklore that there's a common test for AI, and it was developed by Alan Turing. It's called the Turing test, and essentially, if you can talk to an AI and not realize it's an AI, that means it's the AI passes kind of the human intelligence test. And by chance, I found this app on the internet, and I guess got 5 stars. So at least with written text, it seems like today we're pretty close to the Turing test, where it's difficult to tell the difference between a human on the end of a keyboard or an AI just drafting the text. Now we're going to jump into the ethical considerations here. And these are mostly, since AI is kind of new, these are more cautions for the future and what to look out for, but some of them might be actually impacting you today. And I think a lot of these come out because unlike conventional software that's used in the past, it has some more human-like qualities, which could become, create some more legal, more ethical type issues. This happened quite a ways back, but essentially Amazon was trying to use AI for its recruiting. And with the thought being that obviously if I'm using software to do the recruiting, it's going to be less biased than humans, that's what you would think. But actually the problem is with this this training cycle is that if you're using successful candidates in the past, the problem is if they all happen to be, in this case, men were the successful candidates in the past, and if you kind of train it on men, then the AI's going to might associate features with men and discriminate against women. And in this case, if it said it was scanning resumes, and if it said like women's chess club or something like that, it would essentially kind of give those candidates a low weight, which is obviously not what the intent of it was at all, because obviously the woman in the chess club is maybe somebody you'd want to consider hiring. But that's what happened here, and that can create issues here. For example, Model Rule 8.4 for misconduct, and it states here, it is professional misconduct for a lawyer to engage in conduct that the lawyer knows, reasonably should know, is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. And it's essentially, in this case, like with the Amazon hiring, this would obviously be bias based on sex, and that's obviously a problem. So if you're using these AI tools, you have to look out for these issues, because you don't want to be like biased against race or sex or anything like that based on just like an AI having biased input data. And another issue with this is that like a lot of these recruiting sites that you might be outsourcing your recruiting, and that could be done like, although I don't know what algorithms ZipRecruiter does, or whether even they're really using some sort of deep learning neural net for their recruiting. It could be just because AI is like is a big buzzword today. But if they are using AIs, they could be sending you back biased results, and you just might want to double check on what they're doing, because if you're only seeing, like in the Amazon example, if you're only seeing male candidates come into you, there might be something wrong with the outsourced AI, and you might want to reach out, either maybe switch to a different vendor, or consider just discussing this issue with the vendor and seeing what the problem is. And this was an interesting story. In the past, there was a Harvard professor, LaTanya Sweeney, and essentially she just noticed that when she went on she's getting pushed ads to her, and she was a Harvard professor, and she's getting ads for essentially, I believe it was for criminal record searches. And she just found that really odd, and then she kind of dug into it further, and then she found out that essentially people with black sounding names would get ads pushed for criminal record related ones, where if you didn't, you would get, and I forget what the others would get, but they would get ads like maybe for t-shirts or something. So this is something to just be aware of. Like, for example, if you ads on your website, you might want to just monitor them a bit. Or if you're going on social media, that they use a lot of AI there, so stuff around you could be pushed to you that could be biased. It's just something to look out for, because with these ethical issues, although you might not be doing, it might not be you specifically doing the issues, it's almost always imputed back to the attorney that's supposed to be supervising these activities. Another interesting situation is that this was a case where they found there was a racial bias in medical algorithms. And in this case, they actually purposely stripped all the ethnicity from the record, so there should be no knowledge about the patients. But one of the criteria they put in there was who would cost the healthcare system more in the future. And for just for past reasons, it ended up that black patients tend to use, after they got diagnosis, tend to use the healthcare system less, and non-black patients tend to use it more, and end up being that the non-black patients tend to use it $1,800 more in the future. And for the way they were sorting it, they were actually giving people that were probably more overserved more services, because they thought that by essentially providing them services now that they would use less healthcare in the future, which was obviously not the intended consequence. So kind of like this black box algorithm that's in these AIs can kind of have these unintended results that you just have to be cognizant of when you're using AI in your own practice area. Now, this was a kind of a horrific case. I think most people are aware of this, but essentially an Uber was using autonomous driving, and you could see like the video on the internet and on the news. And essentially this car just drove, and there was a woman walking a bicycle across the road, and the vehicle for some reason just didn't recognize that there was a person there for whatever, whether it was like some reflection off the bike or just the lighting conditions or some malfunction in the hardware. But essentially this Uber just drove and essentially hit the bike rider in this horrific accident. And it's something just to be aware of, that it's kind of like this black box concept with the AI. You don't know what's going in there, so it might work reliably 99.9% of the time, but there are these odd corner cases that can happen. The lighting was just right, that because it was a bike and it had spokes, it didn't recognize it. Some weird condition like that essentially, if a human saw, would recognize it right away, that this is a bike rider, I need to slam on the brakes and make evasive maneuvers, where in this case it didn't happen. And this can obviously lead to some issuances with competence. I'll turn it over to Jay here.
Okay, sure. As Jeff indicated, we're going to go through a number of the model rules and show how AI issues can pop up, and there are things that you should be aware of when dealing with AI. And the first one is competence. So model rule 1.1 says a lawyer shall provide competent representation to a client, and that includes the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So AI is not used a lot in the legal field right now, but it is being used. And one of the areas where it can be used is in document production. Document production is extremely expensive. You're always finding ways to try to do things more efficiently. So although it's really not an issue right now, over or under reliance on AI for legal work can be cause for a client to question an attorney's competence. So how can that be? So for example, if an attorney fails to find a critical document in a lawsuit by a manual review that arguably would have easily been caught by an AI tool, maybe you run the same information through an AI tool and it finds it, a client might take issue with that, where in the case that the norm becomes AI-assisted document review. So we're not there yet, but in the future, this could become an issue. In the alternative, if attorneys just go and AI is the norm, and attorneys just go and uses AI solely for the document review, and it misses a document, as in the case of the self-driving car and the epic fail, over-reliance on AI could be a problem for the attorney. So it's problematic in both. So either you use it too much or too little, it could be a problem. Next slide, please. Again, this goes to Rule 1.3 and diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. So the question is, are there situations where you must use AI to get the job done promptly? Again, not now, and I won't keep going over this, but not now because it's early yet. But in the future, this is an issue you're going to need to look out for. AI is much faster than humans, so not using the AI may be the basis for a lawsuit claiming that an attorney is trying to run up the bill on a case. Just something to think about. Next slide, please. So a lot of these situations can be dealt with getting into Rule 1.4 and communications with the client. So the question is, in which situations do you need client consent to use AI? Like in the prior situations we discussed. So the issues of competence and diligence can really be addressed with clear communications with the client. So Rule 1.4 A2, you can see that a lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. So I would argue that using an AI-assisted tool is certainly means by which the client's objectives are being accomplished. So it's a good idea to communicate with the client clearly in these types of situations. So early on, it's probably okay using rudimentary AI tools for work, which are largely then reviewed by paraprofessionals or attorneys. However, such a communication is almost certainly needed if you're using AI instead of paraprofessionals for contract review or massive document review. And again, it's much easier. You let the client know what you're doing up front, and that will, if not dispel, at least lessen any issues which come up as a result of using those AI tools. And the other thing to consider is that, as Jeff indicated, you might not know the tools that you're using have an AI component, like for document review, for recruiting, for billing. Certain of these things, if you are outsourcing them, they might be using AI. So it might be good to ask the question whether, what your vendors are doing and what their vendors are doing, just to be informed. Next slide, please. Model Rule 1.6 goes to confidentiality of information. So since virtually all AI tools really are accessed via the cloud, there are inherent confidentiality issues in using cloud computing resources. Additionally, remember, as Jeff indicated, the AI crunches data and it learns, and it gets better as it learns more, and you're feeding it more data. Well, that more data can include your client's data. So the question here is, could an AI which is developed or improved using client information be considered to reveal client information, particularly if it's used on other clients' projects? So Jeff will get into this in a bit more detail, in the technical details, and you can see how this really becomes a problem when your client's data is used to train an algorithm which might be used in other ways. So Jeff, you can take it from here.
Well, thanks, Jay. Yeah, we just wanted to get into an example of how the client data could kind of breach confidentiality and some other issues that we'll get into with respect to the model rules. And in this case, we have like the data lake that the AI is being trained in, and if it's kind of learning either on the fly or if it's learning even being taught on the information, like so some example might be in document production, where the AI might learn that certain people's names are more important or certain keywords are more important to use, that the AI is going to learn this information over time. And similarly, like another example of AI use in the legal industry might be contract review. That if you have a massive number of contracts, the AI can kind of do like a pre-screening on them. And then it's going to kind of learn stuff specific to the client, which is very helpful for the AI, because then it's going to become more and more efficient and more better to spot issues that might be important to you. But then this creates the unusual scenario where obviously the data that's put in the data lake of the clients, that's obviously client data. But then does that mean, since the AI has been trained on that data, is the AI actually client data could be considered client data of itself or property of the client? Is the AI more like just like a canned docketing software or something like that, or is it more like a paraprofessional, like a paralegal or an attorney that's actually taught on this information? And with respect to confidentiality, this obviously doesn't apply directly to the legal industry, but there was kind of an interesting situation that with Target, that a father kept getting ads from Target essentially, and the ads were for diapers and baby formula and items like that. And the father, then goes to the daughter and approaches her about, whether she's pregnant or not, because he's getting all this information. So obviously Target wasn't intending to kind of reveal this, secret about the daughter there, but essentially because of the daughter's kind of certain search requests or kind of tendencies of buying. I think this was like a correlation of certain items bought in the store meant that somebody tended to be pregnant, so that they tended to push these ads out to her house, and then her father actually kind of found out that the daughter was pregnant from Target's advertising, which is obviously not what the way the daughter wanted the father to learn about it. So this could possibly, if you have ads, some sort of AI learning to do certain targeted ads or something like that. Luckily, in the legal case, something like this is not as common, but something like this could come out. Another interesting issue is duties to former clients. That clients, unfortunately, we get clients, we lose clients, sometimes clients merge together. So what could happen in the past is that that a client could use like an artificial intelligence on like the clients, like maybe was in a litigation, to document discovery using this AI, and it was kind of trained on a client's information. And then all of a sudden, that the attorney loses the client, and then 10 years later, maybe that client merged with another company. Can you use that AI that was trained on that client's information, kind of, and maybe now you're adverse to that client, that one of your other clients is now suing that client? Can you use that AI on that former client's information? And that's kind of a tough call, because in some ways it's just software and it's just weights in an algorithm, but in other ways it's kind of like some human knowledge, so you could consider it kind of like a paraprofessional. So in that case, do you have to like not use that AI on the client, although that might be your main like document production software, which could be kind of hinder your use. So that could come to this duties to former clients, where like the Rule 1.9 states, a lawyer who has formerly represented a client in a manner, or whose present or former firm has formerly represented a client in a manner, shall not thereof use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has been generally known. So in this case, the question is, if you have AI that was trained by the client and used for that client, would you have to firewall possibly that AI from that former client's work, as you might have to do with an attorney? And then I'll turn it over to Jay for safekeeping.
Okay, thanks, Jeff. Model Rule 1.15 is directed to safekeeping of a client's property. And in particular, it's like keeping the client's property separate from the lawyer's property. And as Jeff indicated, is an AI trained on AI that's trained on a client's information, is that at least partially the client's property? Well, that might be a stretch, but could the client request an AI to be untrained on the client's information? So that seems something much more reasonable and could become routine in the future. And another issue, because we discussed cryptocurrency briefly, this is not AI, but Rule 1.15 specifies that you need to store the client's funds in the state where the lawyer's office is maintained. First of all, offices are going virtual, and there's an issue if you use cryptocurrency that's arguably not in the same state. You're not even really sure what state it in. So if you use a cryptocurrency account, do you need to get the client's consent? In that case, I would say definitely. Next slide, please. So Model Rule 3.4 is directed to fairness to opposing parties and counsel. So in particular, you do not want to unlawfully obstruct another party's access to evidence specifically. And this is involved in data in document production, where you're keeping certain documents privileged. And as AI is trained more and more to do effective document production, the question is, how much, or can you use AI for document production? Like, can you use it to automatically create a privilege log? That would likely be reviewed by counsel carefully, because that's always an issue of contention. But again, another issue that is raised with respect to using AI. Next slide, please. Model Rule 1.5 is directed to fees. So lawyers should not make an arrangement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. So are your fees reasonable if an AI tool could do the same job as an attorney in a fraction of the time? Now, is it the same job? Is it not the same job? You know, again, a conversation with a client in accordance with Rule 1.4, informing them of the options that are available and what you're doing is the best way to go. And you can probably bill for review of AI work, because that's legal work, but how much can you bill for the actual AI? Like, if you're using this tool and you're using it for hours and hours, can you bill an hourly rate? Can you bill it as an expense? That's certainly a question. Next slide, please. This is another AI folklore. This came up, Jeff had found this. There's a website out there, Ava, and it's an artificial intelligence tool that allows the user to use the artificial intelligence to compose emotional soundtrack music. So this shows how artificial intelligence is starting to slowly work its way into our culture. It's already in our pop culture, but into everyday life. So Ava built an AI system that crunched through 30,000 classical music scores for what was considered the world's greatest composers, and the data was crunched to look for certain mathematical formulas and patterns in the scores in order to infer mathematical rules. And these rules are adopted to create original scores. So it might suggest how you move forward, to take from what the masters have done. They show some patterns, and you can stand on the shoulders of the masters to create your own works. Next slide, please. Now we're going to get into AI inventorship. With respect to AI as a patent inventor, it's pretty clear, at least right now, that AI cannot be an inventor. In 2021, U.S. District Court for the Eastern District of Virginia ruled in favor of the USPTO, which refused a patent application because the applicant had an AI listed as the inventor. And really what was at issue, the court agreed that the law, using the term, quote, individual, refers to a human person and not an AI. So if we want to go forward and have AIs considered inventors, this is something that we might have to go, or we will have to go back and change the laws. So, you know, oftentimes, as we know in the legal field, the laws always lag behind the technology, and this is another case there. Next slide. And I think Jeff will delve into this in a little more detail.
Thanks, Jay. Yeah, I think the Thaler case, it made it pretty clear that, at least for now, that AI cannot be an inventor. I think the interesting legal aspect of this is going to be the reverse situation where essentially, can you have inventor-less inventions? Essentially, that if AI creates the invention, and this might be a bit far out, but we did have that Daybus AI in the Thalen case do it, but we'd have essentially an invention that only has an AI as an inventor, and then you have the questions like, can you actually get a patent on it because there is no inventor? You know, conventionally we have declarations or oaths by an inventor. There's really no inventor here. You have assignments from the inventor, typically to like either the corporation, or they can, you know, sell it, or be to the AI itself. So the question is, if you have an inventor, so in the future, the AI use in this might be, because I think typically what would happen today is if the AI invented something, that essentially the person running the AI would put themselves down as the inventor of that case. But such a situation in the future might actually, as if the person running the AI didn't do anything specific, like just gave it the periodic table, told it to come up with a new drug or something like that, and it developed some new drug, came out of the AI, essentially the person putting it in that extreme case really didn't do anything there that was technically significant. That essentially in a situation like that, you'd put like the person who ran the AI as the inventor, and then somebody on the other side might try to disqualify that person as being an inventor because they didn't really contribute to the concept, the AI did, and then is essentially, can you not get a patent on that invention now because it was by the AI? Would it be considered more like a natural phenomenon, or just like an algorithm because the AI came up with it and it's not a person? So I think in the future it might be like the reverse situation where people might want to challenge an invention if they can argue that the AI created it and there was no human had like any contribution to the conception there. So you might be able to do that, challenge a patent in the future on that. And then with respect to like the software before that could produce a song, essentially similarly with copyright, an AI again cannot be an author for a copyrighted material. And again, this was the same Daybus. Obviously, the person running this Daybus software obviously wanted to kind of break the grounds of having an AI as an inventor and an author, and applied for both copyright and patents for it. But essentially here it was pretty, the court again said AI cannot be the author of a copyright. And now with, now I think with copyrights, it's probably, you're probably in a bit better shape because you still have like this, you know, work for hire doctrine. So the AI is kind of employed probably by a company or an individual. So there's probably less of a chance of challenging the copyright based on that. But still, again, like with copyrights, like with patents, the author or the inventor cannot be an AI, at least for now. This is some more folklore here. You might hear about this in like AI circles, called the singularity, and it's essentially the point in time where it's projected, you know, like somewhere in the future, machines might become more intelligent than humans. And essentially, that's called the singularity. Essentially, at that point, machine intelligence is smarter than human intellect. There's also other similar references to where machines, when machines get the point where they can improve themselves, like an AI can write an AI that's better than themselves. That would be the singularity, where essentially machines can become smarter and smarter, and without any human intervention. And that's referred to as the singularity. And I'll turn it over to Jay with we're switching into the patent matters here.
Sure, thanks, Jeff. So since 2014 and the Alice decision, patent attorneys have been wrestling with the patenting of software. So since AI is very much software related, a potential issue with patenting AI inventions are the eligibility requirement of Section 101, which prevents or prohibits inventions from claiming, among other things, abstract ideas. Most of the rejections center upon the concept that if the invention is just replicating human steps that can be done by a human, there is no invention. However, as Jeff indicated, AI itself is replicating human capabilities. It's replicating the way to think like a human. So this is a further complication on top of, for AI on top of the regular patenting of software. Next slide, please. Of course, with AI, we still have to address all of the other patentability requirements, and we'll just go over them briefly. One is novelty, like is this invention exactly like something else that went in the prior art? Usually the answer is no. It might be completely different, which is fine, or it might be close, but it's not exactly the same. So it'll overcome the novelty objections, but under Section 103 and non-obviousness, if the invention is close to what has been done before, but not exact, the examiner might say, hey, well, it's obvious in view of the prior art. So again, AI still has to meet these or overcome these requirements. Next slide, please. So a particular concern with respect to AI is enablement. So although the threshold is pretty low for software inventions, it could be problematic if the AI is like the glue that holds everything together. So, and that's the reason often AI is seen as a black box and the details are not disclosed. So if you're looking for detail to support the claims, it will not be there if you don't write the patent application correctly. If the AI is very successful and a client wants to patent it, they're going to need to provide all of the details, enough to, maybe not all the details, but enough to support enablement. And the question is, do you really want to do that if the AI is really successful? And that's one of the things, although it's not necessarily AI, but Google's algorithms have really been kept as a trade secret rather than disclosing them in patent applications, because probably by now the patent applications would have been published, and by now they would be public domain. So these are the considerations we need to address when we design a strategy for a patent application, whether to file it in a patent application or to keep it as a trade secret. Jeff, I think over to you.
Yeah, we're just going to go over some examples of how AI would be an invention. And this would be kind of a typical scenario where we have a process that has, like, for example, step A, step B, and step C, and then a step D, which is performed by an AI. And collectively, these steps would create a new and novel and inventive invention. That'd be like a typical scenario that AI would be involved. Now, a problem could arise, and this is unfortunately a typical example, and it could be, and it kind of falls right into Alice, where essentially a process with A, B, C, and D is the prior art, and essentially we're just replacing D with essentially the artificial intelligence, and maybe you could argue that essentially the artificial intelligence makes it go faster than the process did before, or it's more accurate than that. That would probably be pretty tough to get a patent on that unless there was some unexpected improvement, not like a straightforward like automation type of improvement would be. Another typical situation that it could occur is that you have process A, B, C, and D is in the past was always performed by a human. today, you know, that you might do it with A, B, C and have the AI replicate what the human does. And unless, again, there was something uniquely different to using the AI in that scenario and they were essentially replacing the human, that's going to fall probably on the 101 type Alice scenario where it's going to be really difficult to get a patent on something like that. Another scenario that AI could occur in invention was like you had to process A, B, C, and D, and then you added kind of like the processing of the AI, like for example here between step C and D, and essentially it actually improved the whole process or did something totally different or came to a better outcome. That might be something you could get a patent on. Obviously, the AI itself is something that you could get a patent on, like you improve the artificial intelligence algorithm. Although algorithms in and of themselves are going to be difficult to get patented, you might have to apply to some application, you know, to get it allowed, some practical applications, because the algorithm itself would probably be not patentable as just being an algorithm, but using it in a particular application, you could get it. Just creates a difficulty in claiming, trying to cover all the different possibilities that this algorithm could be used. Another typical way of using it is defining the inputs and the outputs, because that can be an important way of defining the AI, essentially what's going in, like I'm putting in 10 pixels from an image, or I'm putting in certain features in there and I'm trying to get certain outputs. So that would be a way of doing it, kind of like, you know, the way Google in the past used links to other websites as to do an improved search engine, something in the way of defining the inputs of the output of the AI. Could also be used as an invention. And obviously, if there's multiple layers of AI, that essentially the way you have the inputs, the outputs, and the features that get passed in between them would be a way to do this. And although this wouldn't be patentable today, that something like an example would be like a personal assistant, where essentially in practice, you know, you talk to the Siri or Google, and essentially the text goes, you speak, and then it'll go up to a server. The server will convert the speech to text, and then the text will be put into an AI, obviously much more complex than this, and then a response will then be produced. That response will be produced in text, and then it'll be converted from text to speech and given back to the user. Now, this isn't exactly an automation of a human, because a human learns speech and they just respond to the speech and they never convert it to text. So adding kind of a layer in the middle could be inventive. Like in this case, obviously, this is well known by now. And I'll skip the next slide. It's just an explanation why human voices are male versus female in view of the time. Another way could be the ranging of the AIs, the artificial intelligence, like the layers of the neural net, for example. This could also be patentable, the way it's all arranged with certain AIs doing different functions, and how that's arranged could be something that could be patented as well. And I'll skip over this text in view of time, and I'll turn it over to Jay.
Yeah, thanks, Jeff. So the last requirement, patentability requirement that we're going to look at, the next 3 slides, are AI claiming and nonce words. And these nonce words are claims, terms used in claims without supporting structure. So think, you know, processor, module, unit. So examiners construe them to cover the structure used in the specification to describe the invention. The problem is, if there is no structure in the specification, you know, enablement is questioned. Next slide, please. So the Williamson case reinforced the notion that even though means plus function, which are the historical, you know, historical way to invoke 112F, the use of nonce terms is now in that category. So next slide, please. So the problem is that everybody's idea of the nonce term is different. So in the Lacala case, the USPTO ruled that a processor is non-structural and needed to be defined. But in the sync point case, the court said that 112 paragraph 6, the term processor has a plain and ordinary meaning. It does not need further construction. So there's a lot of uncertainty in the use of these terms, and many of these terms of which would be used to describe an artificial intelligence type invention. So I'll turn it over to Jeff to close it out.
Yeah, with respect to the processor, I think it's for these AI inventions, you're probably going to have to use the term because, you know, in practice, it is essentially software running off a general processor. But, you know, it's just something to be aware of that, you know, the PTAB, at least in the past, has considered a processor a nonce word, which could provide problems in the future. And then one thing to always be aware of with these AIs, like for example, in the personal assistant scenario, is that they're usually, frequently they're tied to like the cloud environment. And then with the cloud environment, you always have your computer or your cell phone is communicating through internet service provider, then it's going up to the cloud, and then there's functionality on the cloud. There could be functionality on the phone or the computer for the AI or just in software in general. And then the issue is that you generally need the single infringer. And the Akamai case kind of discusses a scenario where you can have kind of multiple infringers, like in the case of an agreement, a common purpose, you know, an interest in common. But the difficulty is when you claim them, you obviously want to claim a discrete component, but sometimes it's nice to claim the whole system in and of itself because you might get a bigger damages space there. So it's obviously good to have a variety of claims, but sometimes the challenge is that maybe the invention really is divided a bit among like maybe different server farms or between the computer, the cell phone and the server. So essentially, you might have to use like an indirect infringement argument, such as inducement to the customer or something like that, to actually get him, because of like a lot of this AI is in the cloud essentially. So it's creating these kind of divided infringement issues. And thanks. And Anna, are there any questions?
There are no questions at this time. So thank you, Jeff. Thank you, Jay. To our audience, again, I apologize for the technical difficulties with the handouts. We did put a link to the Google Sheets in there. I will also make sure that we email the PowerPoint out to you after this presentation. Jeff and Jay, do you have anything else? Okay.
That's all.
Well, I guess we do have a part 2 of artificial intelligence coming up in the fall. We'll have some updates and additional information if you're still interested, and stay tuned for that.
All right. On behalf of Volpe Koenig and Jeff and Jay, we wish you a good afternoon. Thanks for your attendance. Bye-bye.
Thank you.
Bye.